because now that we have some facts, the caller states that there's police everywhere. The neighbor, the supposed neighbor, I don't know if there is a neighbor, but the supposed neighbor supposedly walks by police officers at least twice, leaves the house. She's not being held in the house. She calls, the caller is calling, the caller relates to the 911 operator that the supposed neighbor calls during the 911 call. She states that's them calling now. So, Your Honor, when I put up all these rules that it shouldn't come in because the witnesses aren't here, that's where we start. These are exceptions that the state wants. And I can't get out of it. And then, I listen to the demeanor. I listen to this call a lot. That call's demeanor is not panicked or frantic. It is relaying information that she may not have, she may have, it may be right, it may be wrong. That's why I can't get over it. And when the part, if the Salvo Court disagrees with everything I'm saying for the Confrontation Clause, and you find it to be non-testimonial, then I still come back to Pitts, because it tells us it's not so simplistic of tale, admitted or excluded. You have to look at redacted. I don't know how that shot somebody named Young Thug or whoever that's supposed to be shot somebody. How is that non-testimonial? Now, if it was that Young Thug got shot or Young Thug shot somebody and that guy's a brutal assassin, he is known in the community for murder, he is a villain of villains, then I think it's closer to Pitts. I still think it's away from Pitts because it's not the caller. But then it's closer to Pitts because, Your Honor, at that point you're giving context. Why is this go to the emergency? But to say simply, she came running, she came to my house and told me that the guy that shot somebody named Young Thug or whoever that's supposed to be, that means she doesn't know it's Young Thug. So, and that's not going just to trustworthiness of, which I know we have to get to, of excited utterance or repeating excited utterance. That goes to, or whoever that's supposed to be. She doesn't even know who that is. What if it's not Young Thug? This Honorable Court may be letting in an unconfronted call with two people, and what if the witness was here and she said, no, I don't really know if it was Young Thug. That's what someone else told me. So the point I'm trying to make to this Honorable Court is I do believe there's testimonial, but if the court disagrees, can I get you 1 second? Of course. Can I just step back for 1 second?
Ooh, the judge got upset. Mr. Steele. Mr. Steele got upset. Look at him. It's heated, y'all.
No, I'm sorry, Mr. Steele. Go right ahead. So, the three reasons that to answer the court's original question is, I heard your potential leaning. I'm not saying you made a decision, but that it may be an emergency. I don't believe the emergency is created by the circumstance. The emergency is created by the caller, or in this case.
I fundamentally just disagree with that stuff you have going on with the emergency in the court's opinion. So, but the question there becomes is, I got to make, like you said, I can make a decision whether or not the call is testimonial or non-testimonial, purpose of the call, and then depending upon that, then I also have to decide, as in Pitts, whether or not any part of this conversation shifts from being non-testimonial to testimonial. So you are correct about that.
So I thought, Mr. Matthews comes to me and states, hey, this is a guy in my apartment, can't get the guy out, has a gun.
Has a what?
Has a gun.
Has a gun.
Has a gun. Mr. Matthews says, but, I'm going to go back to the apartment. Walks by all these police officers both ways. I call the police and I say it's not an emergency, but here's what's going on. The reason I give you that is, but I don't realize that anything happened with a car slamming into a wall and one person supposedly escaped capture. I just don't realize that. So the emergency really not have anything to do with the capture. The emergency has to be with Mr. Matthews. Now, if Mr. Matthews carries the day and he says, hey, that's an emergency, and the court finds that, that is one layer. Then, of course, I'm the one making the call. I'm not going to be present either as a witness, so I have to be in that zone where it's non-testimonial. Now add, and I'm not sure, but I believe that it was the Honorable Max Shard who was in there with the gun. But no information about Max Shard, his background, why and then I say, and I don't know. How is that piece, regardless of everything else, how is that piece about Max Shard not anything but testimony? It goes to, you're calling 911. You're not talking to somebody else. You're calling 911. That is, and by the way, the perpetrator may be Young Thug, may not be Young Thug, by the way, but maybe, and we can't cross. So those are my reasons, Your Honor. I just can't get by the fact that the supposed emergency victim walks by police twice, and I don't think that we could just say, well, maybe she didn't see the police. If we're looking at the totality of this 911 call, and then what the police officers say, is the 911 call says there's police officers in the area or everywhere, whatever the right word is. In addition to that, you asked about, this is near the place where the incident occurred. There's no evidence the caller knew that. The car slamming into the wall.
I have to know that, but it gives context in terms of why or how you've got a jury may decide to believe that, hey, from the testimony that's been deduced so far, that this person actually ran and then posited themselves into this apartment complex, and that's for them to decide. But it does give context about how somebody.
But they don't know who.
That crash site, and then went into an apartment.
That's testimonial if you used Young Thug.
Okay, I understand. All right. So anything else?
Well, we didn't even get to the other part. You want me to do that now too?
Sure. What's that?
Well, I've been focused on the constitutional right, and then of course there's the present sense impression / excited other.
Well, you can finish that, but I have to, because if I decide that it is, that some part of it is non-testimonial and some part of it is testimonial, then I will excise that particular, that sentence, or that name, I should say. I don't see anything else in the transcript would be testimonial.
I can see that if you make those findings, yes, that would be the one.
All right.
Action. Yes.
Okay, I'll see whether or not that, based upon the state's argument, if I need to hear more argument, I'll let you do that.
Okay. Then I'll reserve the, if needed, I'll reserve the statutory ground.
Okay.
All right. Thank you, Your Honor.
Okay.
Good job, Steele. That's my boy there.
Your Honor, I'll start out by being clear. It is not error. There is no error in admitting the entirety of the call. The first words out of Mr. Steele's mouth this morning were in relation to the frantic 911 caller. That's what he said, the frantic 911 caller. But I'll get to his last argument regarding testimonial and not testimonial, because the confrontation clause is the first assessment that the court has to make. Mr. Steele's argument is that had the caller said, Young Thug is known for committing crimes, all of this, that would be closer to Pitts. In fact, that is the type of information that would be testimonial. The fact that this caller is giving to the 911 operator all of the details that she has gotten from this panicked neighbor who came to her in an effort to get the police out there. The fact that she says Young Thug or whoever is in her house just shot somebody. That is information that is a part of the ongoing danger that she perceives the neighbor as.
Let's say I do that. Let's say I agree with that. But wouldn't Pitts tell me that I've now shifted from, or potentially that particular portion would shift from being non-testimonial to testimonial? Because remember, we have no way to, because it is a specific, like, hey, this dude, Young Thug, is in the apartment. We don't even know the context. We really don't. We don't. But why wouldn't that be testimonial? That particular piece, because that's what Pitts tells me I need to do, is that the courts have to be careful. The primary purpose is shifted in such a manner as to render portions of the call testimonial in nature, and should selectively redact portions of the recording when that's the case.
Because the entirety of the call remains the caller's effort to get the police.
I disagree, because that's not what Pitts tells me I need to do.
Your Honor, what I'm saying is that in Pitts, the person who called in Pitts, when she began to give, and just to say that when in Pitts, they began to speak information about the background.
Plus, you didn't have a third party emissary. You had the actual person or the who was being perpetrated against actually calling.
So as we're focused on the confrontation clause, it either is testimonial or it's not. And whether it is testimonial,
I would agree.
And whether it is testimonial or not depends solely on the purpose for the information that is being given.
However, we do caution in certain circumstances that a caller may shift from non-testimonial statement into a testimonial one. And then they talk about what Ms. Pitts have explained to the 911 operator, that her husband violated his parole and he was wanted. So how do you distinguish that?
Because the information about her husband being wanted and violating his parole, and even that they did not consider to be testimonial. That is closer to testimonial than the person saying, this person is in her house. This person is in her house having just shot someone and she is panicked and is in there. Her mother and her child are in there. The testimonial portion, the parole portion, is not at all akin to her saying, my husband did this. The fact that she is saying it is her husband who committed the act, who is committing the act, is the part that is not confrontational. The fact that she names the fact, non-testimonial, my apologies to the court.
That's all right. Sorry.
The fact that she names the perpetrator or who she believes to be, the fact that she is giving information to the police to get them there and giving information to help them respond to this ongoing threat that is in her. They have to have this information in order to be able to properly respond. They would not need the information about the husband being on parole or being wanted, but even that, the court has decided testimonial. That's how you know that this information that this caller is giving the 911 operator in this case, this information is non-testimonial, because it is even more of an effort to get the police to respond to a threat that is in existence at that time. The information as to who it is only akin to the caller in Pitts talking to the police about what it is that her husband is doing. Her husband is doing a thing at that moment, not he is on parole or is wanted.
But they make the distinction in Pitts that because the crime was still ongoing,
Right.
in her presence, however, their primary purpose remained the prevention of immediate harm to herself, and the statements regarding her husband's parole were made to illustrate the prior difficulties. It made the current situation such a dangerous one. So that's how they distinguish, and they say that the entirety of the call is they authorized it, but they do say that that courts now must decide what the caller's primary purpose has shifted in a manner to render portions of the call testimonial. So that's what I'm kind of resting with at this point in time. So I think a little different than Pitts. Pitts, you've got, like I said, person directly under the unfortunate situation of somebody who's committing violence.
And Your Honor,
And clearly committing violence. In this particular circumstance, you got intermediary who's relating information that is going on. So I have to kind of look at that a little more carefully than, because each individual situation is different.
and to the court's point, when the court speaks about the threat, the ongoing threat, for the caller, the ongoing threat.
And Pitts are in the circumstance at hand.
When the court spoke about the ongoing threat that the court, when Your Honor spoke about the ongoing threat in Pitts, that the court addressed the caller attempting to have the police respond to. It is akin in this circumstance when the caller is saying, I know she came to my house and told me that the guy that shot somebody, whoever he's supposed to be, is in her house. So I don't know how y'all can do that. I'm trying to get her out the house, but she won't answer the phone now. That is the ongoing emergency. And just to give a little bit of context.
Not really.
Heard, but I don't believe that it is.
Not really.
Anything at all that any evidence has come in to suggest. I heard the suggestion that the caller walked past police twice and gave him or didn't give him a phone or something like that. But just to point out where we are, Your Honor, just to make certain that the facts are crystallized in the record. Officer Black testified. Just 1 second. I'm pointing on the screen. There are two separate phases to this apartment complex, Summerdale. The phase where the red dot is, Black testified that is the phase in which the car crashed, in which the shooting first occurred. Then Officer Black, we've heard testimony that the went through the yard just across the street diagonally, and we have other pictures that I could show to the court that better reflect what took place. The court can see in State's Exhibit 129 Charlie Alpha, put that up on the screen, and I'll just hold it up for the court, that there is a dearth of shrubbery. We can see that Summerdale Apartments, the one phase is here. You can go ahead and keep the overview up. One phase of Summerdale is where in 129 Charlie Alpha, I'm holding up to the court. It's
Here it is. Okay. It's still 150.
Go ahead. I'll use 150 and then I'll go to 129 Charlie Alpha. If you would point on the screen, Mr. Atkins, to the first phase of Summerdale Commons, where the car and the shooting first took place. After the shooting took place, the car went across the road into the laundromat.
Yeah.
After that, the occupants of the car, two
Jumped
of them
out.
jumped over a fence. One went left, which is the area where the arrow is, and one went right. Those trees, as Officer Black testified, there wasn't that much greenery. What it looked like is on 129, more like 129 Charlie Alpha. Can you put that on the screen?
All your favorite brands are now
Woo, yeah. Here we go. Sorry about that, y'all. We already seen this. What was she talking about?
You have a 129 Charlie Alpha. And as that is coming up, Your Honor, I will say to the court that the court has heard the testimony that the area of the phase of Summerdale Apartments where the shooting first occurred, that phase is identified by numbers. The buildings are identified by numbers. In the second phase that the caller was calling from, the court heard in the 911 caller, we're in the, not the old Summerdale, the new ones, and that it is in building C. Officer Black testified that the second phase of Summerdale Apartments, the ones that in
Summerdale Commons?
yes,
Okay.
that second phase, those buildings are identified by letters, and the letter C, the building C, is exactly where the caller identified it as being. We're in the.
I understand.
So the idea that the panicked neighbor went past police officers twice is a fiction being made up because the police officers are in the first phase.
I need to take a look at 29. I mean, 150.
I'm gonna just go ahead.
Put 150 back up if you can. I'll take a look at 29C, please. Put 150 up, please. All right, so it starts at Summerdale Apartments, and it goes to Skyline Laundromat, and then two of the alleged suspects end up at Summerdale Commons. So
One of them
the one that is in Summerdale Commons, that's where the 911 call is coming from.
yes.
So when she's saying police, or she's identifying police, where are those police? Do we know?
The police, the evidence that we have is that the police, they were in the first phase of Summerdale Apartments. And they are also down at the laundromat because remember, that's where
Yes.
Adrian Bean gets hit.
I don't know that yet, but okay, I don't know that yet. So, but
Right, the name, well, we'll say one of the people in the car gets hit. That's what the testimony has been so far.
I haven't heard that. So, but anyways, of note to me,
So what are you getting to?
the court is your caller, the 911 caller is calling from Summerdale Commons.
Yes.
All right.
I'm skipping it.
Fox is the one that said, man told me if anything ever happens to me, Carter did it. And in our case, we have a 911 caller saying, my panicked neighbor told me Thug is in her house.
A little different now.
She could be lying. We don't know.
It's just fundamentally a little different. So Carter versus what we have here.
Your Honor, the analysis, I understand that the defendant would rather not have his name mentioned, but the fact that he feels
That's not the point, Ms. Love. The point is, Pitts tells.
She need to get out of her feelings.
Then Chief Justice Sears makes it very clear. Courts are determined and take a look at 911 calls in particular about some things that may be non-testimonial and testimonial.
That's right.
That's kind of what we have to kind of do in this particular circumstance.
And
And that's why I'm kind of concerned that, and especially since it's being communicated through a third party, but it specifically names Mr. Williams in that particular regard.
and if I may, Your Honor, when the courts, every case that we look at, there is never a word by word analysis. The court looks at the entirety of the statement to determine if at some point it turns testimony.
Well, you're right, and that's what Pitts tells me to do.
And the
So I have to kind of look at it from that standpoint.
and the intent of the caller is what makes the statement.
The caller can be lying.
The caller intends.
But some portions of the statement, remember, that's what Pitts tells me to do. I have to look at whether or not some parts of that statement
That's right.
are testimonial.
Right.
So
And
that, and that's kind of that's what Pitts.
But they might not like Young
it's
Thug.
only testimonial, Your Honor, if its primary purpose is to establish evidence that could be used at a future trial, in a future prosecution.
Well, I would think that naming a potential suspect would be evidence useful in a prior trial. Now, I know you're shaking your head over Miss Hilton, but that's. I'm sorry, okay? That's just the facts.
That is the fact.
That's just the facts, okay?
Hey,
It's
Shirley.
It may not. Evidence may not cut. It is what it is. It cuts both ways.
That's
So
right.
It's kind of like this is what our highest court tells me I have to do. Now, you all may disagree or not like it, but that's what I gotta do.
I agree with Your Honor, absolutely. And all that I'm saying, Your Honor, is that every single case that we have regarding the confrontation clause, in every one of them, a person is named. The person
But they can be lying on Thug.
is alleged to have done the
They might not like Young Thug.
them to make the statement.
Mm,
In every
it depends. Like I said, it depends on. You have to look at. Crawford tells us in his progeny, and even in our jurisdiction in Georgia, you have to look at the primary purpose.
That's
of
right.
the call. Was it testimonial nature? Was it made for the purpose of gathering criminal or fostering for use for trial or for potential criminal prosecution? There are certain exceptions to it, and the emergency situation is one. But even with the emergency situation, Pitts tells me got to look at whether or not some of those particular statements are in fact testimonial. So even if I believe, first I got to decide whether or not it's testimonial or not, and even if I decide it is non-testimonial, it's an emergency, then some of that's then I have to look at, and Pitts directs me, I got to look at very carefully whether or not some of those statements are in fact
Shirley, you tell them to hit that like button, they'll run,
maybe
girl.
testimonial in nature. So that's what I'm required to do.
And Your Honor, we are looking at a caller who's describing and trying to get the police to respond, even when the 911 operator is asking her who was shot. In other words, she's telling her, I need you to come. I'm not sure what the apartment is. She's in building C when you're coming around through the gates. The 911 operator is trying to get information about the shooting because she said that shot somebody, like it's already shot somebody. 911 operator tries to get information about the shooting. She said, I promise you, I can't tell y'all that. I ain't trying to talk to you about that. I ain't trying to give you anything for your evidence for your prosecution about no shooting. I'm telling you that the guy that shot somebody, Young Thug, is in my neighbor's house, and I'm trying to get her out the house, and she won't answer.
Well, how she know?
About who got shot or who he is alleged to have shot.
How she know somebody got shot?
He's in her house now. This man, potentially armed, is now in her house. The reason that it is important that she names him and that she says who he is and what he does is twofold. So just with the information that the court has already heard, the court already knows background. But just for future purposes, there is an accomplice statement that we intend to have presented as evidence that I will state in my place that
Well, if that,
ran one way,
see, my thing
and
is
Thug
this.
ran in the opposite
Hold up.
direction.
My thing is this. If the officer thought that Young Thug was in that apartment building, they would have came. They ain't come because anybody can say somebody in a how that lady know that Young Thug was in a shooting? These folks are lying just to get the police out there to your area. They didn't see Young Thug when they went out there. They didn't see Young Thug in that apartment. They trying to catch that
This
boy on something.
direction is exactly where this caller is calling from. I should have followed Thug. I should have went left. I went right, or I went to the left and he went to the right. I should have followed Thug. And then here we have this caller saying, I ain't trying to talk about this shooting over here. I'm trying to tell you that this man that just shot somebody, Thug, is in her house. And I need you to get her, I need you to come and get her out because her mom and her baby are in that house.
Okay.
And Your Honor, that's the reason those
So she making Young Thug seem like he a criminal.
the caller's words, her purpose that she
I don't know.
revealed. When she tells the 911 operator, I can't tell you all that. I don't know. I don't know who got shot. I don't want to talk to you about that. The only thing I want to talk to you about is the reason I'm calling. Because Thug is in my neighbor's house and she's panicked. Just as if the court...
Why she panicked, though?
You're going to go and respond to someone, you'd want to know who it is and what it is you're walking into.
See, my thing is this. My thing is this. Hold up.
Somebody's in our
Hold
neighbor's
up.
house. You want to know, is he armed? Who is
Okay. Why are they making Young Thug seem like he just a big criminal? He a crime artist.
happening right then? You would not want to walk up to a circumstance you don't even know.
That okay. My thing is this. Why did the neighbor make it seem like he's a thief, he a killer, and he just ran up in her house and he don't know her? Why is the neighbor all into this girl business? That because she said Young Thug came into the house, ran into her neighbor's house? You sound like he got her hostage. That's how she sound like he got her hostage. Ooh wee.
Remember. So, but how is it different if
Y'all get the lights up.
if the person is directly communicating the information to me, or am I getting it through somebody else?
Your Honor, that part, it is not different for the confrontation clause analysis. That part remains the same. Its purpose remains the same. When you get into who said what, that's the hearsay within hearsay, and both of those statements fall under 24-8-805 to an exception. And the court analyzed it exactly correctly when the court said that's for the jury to determine. Because Mr. Steele argues, you don't know that that was actually true. The court analyzed it on point. The court said, well, you can argue that, and the jury can say, well, she said she don't know. I don't know. The jury can decide what portions, if any, of that 911 call.
We don't have a declarant. Our declarants unknown. Our two declarants are unknown.
And that is why, Your Honor, the whole purpose for exceptions for hearsay are to put forth things that are trustworthy. And hearsay within hearsay is not, it is absolutely admissible. And the court knows, I don't even have to say this, it is only for the purposes of the record, that these new evidence rules are rules of inclusion. So much so that the rules don't say it can be admitted if you have an exception. 24-8-805 specifically says hearsay included within hearsay shall not be excluded under the hearsay rule.
Well, Ms. Love, I'll tell you. Spratland, which was decided in 2023, says if I don't make a proper analysis under Crawford, vacate and remand. So,
And Your Honor,
so I got to make sure I get it right, okay?
and
So-
Your Honor, I'm with the court. I'm absolutely with the court, and I have an equal desire, not greater, to make certain that it is right. And I would not argue fervently for this if it were wrong.
All right, well, let me have 5 minutes, okay? I'm gonna take a break here. Because your 30 seconds is never 30 seconds. You can stand there, that's fine.
You can easily
Ooh wee. What y'all think? What do y'all think?
giveaway of your age. So let me tell
What do
you
y'all think, real deal? Why? Wee.
I'm excited to share a Hollywood secret that's often
I don't think that Young Thug was in that house. I believe if Young Thug was in that house, they would have said something.
Go ahead.
I don't believe Young Thug was in that house, in that apartment.
And I'm not saying you don't understand. The Cardiff case that was just cited, 315 Georgia 214, it's in Division 3. A doesn't apply, that's the 807 residual hearsay. B is what the state was talking about. And, Your Honor,
There was no objection in this case either, so, in the Carter case, no objection, so.
but look what happened.
And they had to review it under plain error too.
Yes.
So, yeah.
Fox was told by this man, God forbid, Valerie Man was killed. Fox testified. Valerie Man, God forbid, is dead. And she told Carter. Carter testified. That is not even close. So I don't have anybody close. And that's my goodness. All right.
And Your Honor, I'll give the court, if the court already has page 3 or 4 of Pitts, where the court said the caller in this instance,
It's just.
okay, was not, they were not concerned with establishing evidentiary facts or bearing testimony. That's the part against the defendant. And the court found that the same analysis was applicable in Pitts, that the 911, that portion of the 911 caller, they were not concerned with establishing evidentiary facts. They were concerned with getting Young Thug out of their neighbor's home.
Okay, all right, give me 5 minutes.
Well, so what they got against Young Thug? I still say, what did that neighbor have against Young Thug? In order to tell that, see, that ain't right. Right there, y'all. That ain't right. They called the police and told the police that Young Thug was in that woman's apartment. And then when they went in there, what happened? They didn't see him. Y'all, they making it seem like he probably run those apartments over there. That's what it sounds like. They do, like a hustler over there in that area. But why would she make it seem like Young Thug held the girl hostage? That's the part I'm trying to get to. Why they making him seem like a criminal going into why he can't know that girl? Oh, I saw Young Thug go in my neighbor house. Get him out of there. That girl might know Young Thug. She all in what it was. She all in her neighbor's business. That's what it was. Ooh, we child. I just don't understand it. I just don't understand it. Just because somebody say, Lanita just went in that house over there, called the police, 911. I don't want to get involved in that, but Lanita just went in that house. Yeah, the only reason why they gonna say Young Thug name because they don't like him. That's all it is. They didn't like him. They didn't like him. That's why. But what is, why would you call on somebody they ain't did nothing? Because y'all heard all them polices? People something else. So when the police went there, what happened? That's what I want to know. So when the cops went to that girl apartment, what happened? That's what I'm trying to see. Y'all can't, a lot of people don't like a person. They'll assume that that's the person in that area. And that person don't have to be in the area. Y'all, they talking about when I showed y'all this scene, this is what they talking about, y'all. Remember the last time the ones who followed me with the Young Thug trial. Y'all remember when they was showing us the area when that car jumped over the wall, jumped over the police car, and hit that red car, hit that wall, the laundromat. This is what they discussing right now. Okay? When they did that, 2 boys one got shot. And the lady called her one. Two ran. One jumped the fence and went that way, and the other went the other way. And the one ran through the apartments. So the girl trying to say, the caller trying to say that was Young Thug in that apartment. But if she called 911, 911 would have went to the apartment. And they would have seen Young Thug. So what? They didn't see Young Thug in the apartment. So what's what? Where we are now? She heard some police. And the first thing she said, Young Thug in my neighbor's apartment. This is what they talking about, y'all. Oh Lord. Oh no. Let me skip it. Look. Ooh, Lord, honey, that's enough to eat some cereal, toast, sausages, eggs, bacon, everything. Let's see. Let me skip it. See what the conclusion. Come on, Professor. Anytime somebody put on their glasses, you better watch out. Because they about to throw the law on you. But that's still hearsay. Because if they thought Young Thug was in that apartment, they'll surround that apartment and come out and drag his butt up out of there. That's what they would have did. They would have knocked that door down and drag him up out of there. If he's a criminal. Come on, Judge. You probably had did that on your break. What you were doing?
Okay, the court's had an opportunity to take a look at and consider Mr. Williams' motion number 40. And in respect to that, has considered the testimony as it relates to a phone conversation with a 911 operator on September the 11th of 2013. The court also has heard testimony surrounding this particular incident involving a purported shooting at the Summerdale Apartments, Summerdale Commons, as well as a laundromat that is in the vicinity where a car crashed into a laundromat. In considering whether or not the 911 call on September the 11th of 2013 would be admissible, I'll note that we have an unknown female who's relating statements from another female in regards to a situation that was ongoing at that particular point in time. The first thing that it implicates is, since the state and has told me that neither the unknown females will be available for trial, then it presents the issue of the confrontation clause. So the court has had an opportunity to consider and determine whether or not the confrontation clause of the United States Constitution is violated by the admission of a 911 emergency telephone call when the caller does not testify in trial. This is similarly the issue that was decided in Pitts. So our Supreme Court Pitts, which is 280 Georgia, 288, holds that the Confrontation Clause is not violated where a caller's primary purpose is not to provide evidence against the accused, but to rather thwart an ongoing crime or seek rescue from immediate peril. The decision in that court cites Crawford versus Washington, which the United States Supreme Court held that the admission of out-of-court statements that are testimonial in nature violates the Confrontation Clause unless the declarant is unavailable and the defendant had a prior opportunity for cross-examination. When a statement at issue is non-testimonial, however, the state's normal rules regarding the admission of hearsay apply. And so, some courts, there was a discussion of the court in Pitts that some courts delineate that 911 calls are totally for the purposes are testimonial because it involves a statement to a government officer. But some courts understand and hold that a 911 call is initiated by a citizen rather than an instrument of the state and is not knowingly given in response to structured police interrogation and should not be considered testimony. So the rule in Georgia is we now hold, however, consistent with the majority view that the determination of whether a recording of a 911 call is testimonial should be made on a case-by-case basis. So, the court first has determined whether or not this particular call, and I'm referring to Williams A for the purposes of this particular motion, which is a 3-page transcript of this particular 911 call made on September the 11th of 2013. So, I have to decide first whether or not the telephone call is made to avert a crime in progress or seek assistance in a situation involving immediate danger, or whether or not the primary purpose is testimonial for the purposes of prosecution or to gather potential information later for prosecution. That's the first step. Also in Pitts, the court or the Supreme Court is also cautionary in terms of trial courts. However, we do caution that in certain circumstances, a caller may shift from a non-testimonial statement into a testimonial one. So it cautions us, or the decision cautions trial courts. In future cases, trial courts must decide whether a caller's primary purpose is shifted from such a manner to render portions of the call testimonial in nature and should selectively redact portions of that recording when that is the case. In this particular circumstance, the court is of the opinion, based upon the testimony that the court has heard, to include the arguments of counsel, to include the admission of the 911 hearing of the 911 call, as well as the defendant Williams number 4, and testimony in regards to the instances of the purported shooting at Summerdale Apartments, the car crashing into the laundromat some short distance away, and the purported phone call from Summerdale Commons. The court is of the opinion that the primary purpose of the call was not for the purposes of prosecution, but more so for the purposes of relating an emergency situation. So the call itself, I'm going to admit, is admit for those purposes and for the jury's consideration. However, going further, as Pitts directs me to do so, I will order that the portion of the call and or transcript that starts at unknown female, I have no idea, baby, I promise you I can't tell you all that I don't know. Only thing I know is that she came running, she came to my house. It'll stop there, it will pick up, the guy is in her house. So I don't know how you all can do that. I'm going to try and get her out of the house, but she won't answer the phone right now. The particular part that I will excise will be starting at Ann told me that the guy that shot someone named Young Thug or whoever that's supposed to be shot someone. I will excise those out as those are testimonial in nature, and the court will so the entire paragraph will read, I have no idea, baby. I promise you, I can't tell you all that I don't know. Only thing I know is she came running. She came to my house. The guy is in her house. So I don't know how you all can do that. I'm trying to get
Yeah,
her
now that's
house,
better.
but she won't answer her phone now. Everything else in the
Now that's
transcript
better.
of that call is admissible as it would relate to an emergency situation. So for those reasons, that's the court's ruling. So, State, if you'll prepare
That's better.
exhibits accordingly. Whatever you decide to play needs to be redacted.
Yes, Your Honor.
Okay. So if you're going to play the 911 call, you need to redact it.
Okay, y'all listen to the 911 call now.
And or the transcript.
Well, we would introduce a transcript and then explain the.
But if you decide that you want to use the transcript as a memory, as a facilitation device, at later, then you would need to, that would need to match, because remember, I'd give a tape and transcript admonition at that point in time, only if it's necessary. I don't think it'll be necessary in this case, because the 911 call case is pretty clear. So, but I'm just telling you, if that's the case, it needs to be redacted. That would need to be redacted. So at a minimum, if you're going to play the call, redact that sentence out.
Yes, Your Honor.
Okay.
Your Honor, with respect to,
Man, play the tape. Y'all talk too much.
Williams' motion, motion number 40, not GO call, yes, the GO call, we did reference it, talking about the 911.
Oh, gosh.
Do not deal with the 911 call.
Man, play the tape.
Accomplice made to his wife on the jail call that he should have followed and shouldn't have gone in the other direction.
It blends together a couple of things. I'm not saying that what you just said is not true. I do recall that as well. So, Mr. Steele, can I get you to prepare a suitable order? And if you'll give that to Ms. Love and her colleagues, so I can look at it as a final order. Yes. Okay. All right. Madam, anything else?
Man, play the tape.
Okay. All right.
She ain't gonna play. Ah. Way to go, Steele. That Brian is bad, boy.
Okay, can we talk about Defendant Williams' motion limit number 38? That's the discovery, and I think that is, no, I'm sorry. That's regards to a pending appeal issue by Mr. Ryan and Mr. Blaylock.
Stop telling me that you need to stay with your car
Woo.
insurance company longer to get that better deal.
All right, y'all. What I'm gonna do is I'm gonna let me see how much more they got because I have to take a nap. I go back to work.
No claims, and I was paying.
Let me see how far we have to go. Guys, Mr. Steele again.
Your Honor, I have cited two cases, Gibson GIBSON versus State 288 Georgia 617. It's in Division 2.
Okay, what I'm gonna do, I'm gonna stop it right here, y'all.
TS, that is 289 Georgia 640. It's in
Hold
Division
on for a
4.
minute. I'm gonna stop it right here. I just wanted to clarify what was the judge gonna say about that caller saying that Young Thug was in the house. I'm glad that he came to look at the rules again, because that could be hearsay. That Young Thug in my friend apartment, and it sound well, they clarify that they can't say that. But y'all go ahead on and hi, Miss Cardwell. Y'all go ahead on and I'll be back this evening. I want to get a shout out to my mods and all my other subscribers and viewers. I gotta go, y'all. I love y'all. I'm out.